By now, if you are follower of the day's news, you have heard that the Supreme Court said today that it will hear a case from Mississippi, of course, challenging Roe v. Wade. That decision way back in 1973 that established a constitutional right to privacy. It involved a case of abortion, but the constitutional right was to privacy. I maintain that. Now, a judicial scholar, a constitutional scholar may say, Malloy, you're full of shit. It was not that at all. To me, that's what it was. It was an issue of privacy. Anyway, this case will give the court's new 6-3 fascist majority its first opportunity to weigh in on state laws regarding abortion or restricting abortion. According to the New York Times, this case is entitled Dobbs versus Jackson Women's Health Organization, and it concerns a law enacted by the Christian fascist-dominated Mississippi legislature that bans abortions if, quote, the probable gestational age of the unborn human, end quote, was determined to be more than 15 weeks. Now, the statute included narrow exceptions for medical emergencies or, quote, a severe fetal abnormality, end quote. In that instance, or in those instances, I should say, then the state of Mississippi allows women control over their own reproductive systems and organs. Lacking those mentioned conditions, though, the state of Mississippi says to a woman, keep your goddamn hands off of my uterus. It may be in your body, but I'm a Christian fascist, and I'll tell you what to do with it. Now, lower courts said this law enacted by Mississippi was purely and simply unconstitutional because Roe v. Wade forbids states from banning abortions before what is now called fetal viability, or I guess it's always been called that. That's the point at which fetuses can sustain life outside the womb, or around 24 weeks. Now, Mississippi's sole abortion clinic sued, and they said that the law runs counter to Roe v. Wade and a 1992 decision by the Supreme Court entitled Planned Parenthood versus Casey that affirmed Roe v. Wade's core holding that it is up to a woman, and in some instances, if the state can detect certain signs of fetal viability, then different laws come into play. And I think, what is it, after 120 days of a pregnancy? I'm not sure, because the laws vary according to various states, even though it's not supposed to be that way. Now, a judge in the federal district court in Jackson, Mississippi, one Carlton Reeves, blocked that law in 2018, saying that the legal issue was straightforward, and he questioned Mississippi lawmakers' motives in saying, in passing this law that took away from women the right of privacy. The judge, obviously not a Christian fascist, although he might be a Christian, the judge said in his ruling, quote, the state chose to pass a law it knew was unconstitutional to endorse a decades-long campaign fueled by national interest groups, read anti-abortion groups, to ask the Supreme Court to overturn Roe v. Wade. This court allows the commands of the Supreme Court and the dictates of the United States Constitution rather than the disingenuous calculations of the Mississippi legislature, end quote. Well, Judge Reeves, I couldn't have said that better myself. Now, he also added this, quote, with the recent changes in the membership, I like that, of the Supreme Court, it may be that the state of Mississippi believes divine providence covered the capital of Mississippi when it passed this legislation. Time will tell. If overturning Roe is the state's desired result, the state of Mississippi will have to seek that relief from a higher court. For now, the United States Supreme Court has spoken, end quote. I like this guy. I like this guy. It may be that the state of Mississippi believes divine providence descended on the U.S. Capitol, or on the Mississippi Capitol when it passed this legislation. Ow! Now, see, that kind of guy, obviously, I'd be willing to bet that Judge Reeves is a Christian, which is great. But I would imagine that he believes in the type of Christianity that Paul and Peter, the foundation of the church, Paul, its chief advocate, and the one who wrote most of the New Testament, I would imagine Judge Reeves holds with the two of them, not with this Christian fascist horseshit that permeates this country and permeates other countries too, thanks to these insane evangelicals. But I like the way this guy speaks. So then it went to the Court of Appeals. It went to the U.S. Fifth Circuit in New Orleans, and a 3-judge panel there affirmed Judge Reeves' ruling. A judge for that panel wrote, quote, in an unbroken line dating to Roe v. Wade, the Supreme Court's abortion cases have established and affirmed and reaffirmed a woman's right to choose an abortion before viability, end quote. Now, there was another judge, James Ho, on that court, who issued a concurring opinion, a little bit reluctantly, and in that opinion he expressed misgivings about the Supreme Court's abortion jurisprudence. This is what Judge Ho wrote. Now, again, this is from the Court of Appeals of the Fifth Circuit in New Orleans. This judge wrote, quote, nothing in the text or original understanding of the Constitution establishes a right to an abortion. Rather, what distinguishes abortion from other matters of health care policy in America and uniquely removes abortion policy from the democratic process established by our founders is Supreme Court precedent, end quote. So, in other words, what Judge Ho is saying is the precedent stands. Now, remember, in the confirmation hearings for the drunk, that would be Kavanaugh, and for Amy Catholic, what's her last name? Barron? I don't know. The new Christian judge on the Supreme Court. And for the one who was supposed to, or who did take the seat of Merrick Garland. Those 3 judges all were asked about Supreme Court precedent, specifically regarding, I would assume, Roe v. Wade. And each one of them either answered that they respected precedent or refused to answer with some legalistic garbage pumping out of their mouths that was supposed to satisfy their questioners. But what Judge Ho is saying here from the Court of Appeals for the Fifth Circuit in New Orleans is that Supreme Court precedent, once the Supreme Court interprets a law, it should stand. Interprets, it not interprets the law, but once the court decides whether or not a law is constitutional or whether it violates the Constitution, It should stand permanently because the Constitution's not changing, God damn it. The Constitution was written 200 years ago, and it's still there. Not a word has been changed, not a comma, not a semicolon. It's all there. So what changes? What changes is the attitude of some of the more liberal or conservative or neo-fascist members of the Supreme Court at any given time. And I think that's what Judge Ho is saying here. What distinguishes abortion from other matters of health care is Supreme Court precedent. In other words, it's a done deal. Now, Lynn Fitch, female, Mississippi's Attorney General, urged the justices of the U.S. Supreme Court to hear Mississippi's appeal in order to reconsider their abortion decision. Lynn Fitch, in her appeal to the U.S. Supreme Court, wrote, quote, "So-called viability is not an appropriate standard for assessing the constitutionality of a law regulating abortion." End quote. Lawyers for the clinic involved in this case, the plaintiff, I guess they would be, lawyers for the clinic said the case was straightforward. They said the law imposes by definition, the law in Mississippi, an undue burden on women who want to avail themselves of an abortion. The lawyers for the clinic went on to say, quote, "It places a complete and insurmountable obstacle in the path of every person seeking a pre-viability abortion after 15 weeks who does not fall within its limited exceptions." Now remember what the exceptions were: a severe fetal abnormality and a very narrow exception for medical emergencies. I guess that means where the life of the mother would be involved. The lawyers added, quote, "It is unconstitutional, the law in Mississippi, by any measure," end quote. Okay, so the United States Supreme Court will now hear arguments in this case during its next term, which, as you know, starts the first Monday in October. And then a decision is not expected until, say, a year from now, the spring or summer of 2022. But I'm sure you've noticed over all the years since 1973, when Roe v. Wade was decided, that a woman had a constitution, well, not just a woman, but a person had a right, a constitutional right, implied, if not specifically stated, a right to privacy. And I forget how the Supreme Court justices of that day put together their decision, but it was based, since it was, let me back up, since it was not based on a specific statement or order or amendment to the U.S. Constitution. It was based on reading the Constitution and its amendments and its implications in its totality. And from that, they decided, well, a person has a right to privacy. In this particular case, Jane Doe or Jane Roe, whatever her name was at the time, who was the petitioner seeking the right to terminate a pregnancy, that her rights as a citizen of the United States were being violated. She was being denied the right to privacy. Now, not shortly, but over a period of years after that, of course, I believe that woman has died, but she reversed her situation after the Christian fascists got their hands around her throat. And I don't know what they threatened her with, eternal damnation, which is what they threaten everybody with. That's what the Christian religion threatens you with. You believe what we tell you to believe and accept the Lord Jesus Christ as your Savior, or you're just going to fucking burn in hell forever. There's no exceptions. Not Einstein. He's going to burn in hell forever too. Not any of the great people of this planet, human beings who weren't Christian. Not all the people who maybe never heard the message that the Christians put out. They're all doomed too. So the evangelicals got a hold of Jane Roe and threatened her eternal existence as if one exists, and scared the hell out of her. So she recanted. Hey, I take it all back. But didn't I read someplace that she took that back eventually too when she came out of the ether of Christian fascism? Jesus Christ, how about that? A religion that just flat out tells you. It just tells you. You believe what we are putting out, or your ass is going to suffer for eternity. Do you know what eternity is? Well, it's a long time. Crazy shit. I mean, just absolutely insane. But the Christian fascists have been working to eliminate Roe v. Wade for decades. Well, ever since it was affirmed by the U.S. Supreme Court that people did have a right to privacy, especially a woman where it concerned her own reproductive organs. That's how you can tell that they are sick out of their goddamn minds.
Hi, Truth Seekers. Mike Malloy here. As you know, we've switched formats and are now broadcast exclusively on the Progressive Voices Network. So that means you get fewer program interruptions, no corporate commercials, and lots of profanity. But our format change also means some of our radio listeners no longer hear the program. It's been a while since I mentioned our podcasts, so you may have forgotten that there is a way to listen to this program anytime you need a good dose of screaming. Visit MikeMalloy.com and subscribe to our podcasts. As a podcast subscriber, you can download the program to your mobile device and take me with you wherever you go. And if you have a friend who needs a dose of truth-seeking, you can give a gift subscription as well. That's MikeMalloy.com, and never miss a minute of the uncensored fun and frivolity.